Good morning, everyone. We're just over 200 colleagues online now, so I think we'll make a start, and those who are on the drag can join us because I know your time is precious. Welcome to the Detectives Insight webinar for Police Federation of England and Wales. I'm Ben Hudson. I'm the Secretary of Suffolk Federation, but I'm the chair of the National Detectives Forum. One of our aims is to try and enhance the role of the detectives across the country, represent you all nationally, look for better terms and conditions, and to bring opportunities of learning to you all. So today is can absolutely, because of our eminent presenter, can be classed as a CPD event. So for all of your PDRs, this can absolutely count as time on CPD for your portfolios. So today I'm delighted to introduce Professor Gary Shaw. Gary joined Northumberland Constabulary in 1977. He was brought up in the pre-PACE era. Certainly interviewing was slightly different when Gary started, and he rose through the detective ranks in that constabulary and during his career, and on the back of getting a brilliant result dealing with an OCG who specialised in ram raiding. He started doing a little bit of crime training, teaching colleagues some of the tips that he'd picked up during that complex investigation. From there, he went on to a national project on interviewing and the peace model as it was in its infancy. And upon his return to force, he started as an interview advisor, a role that Northumberland never had before, and as I suspect at that time, not many forces did. He made that his own, and in 1996 the National Crime Faculty was introduced, and Gary started then helping part-time on that, advising colleagues and investigations around the country on interview strategy. In 2004, Gary became the National Interview Advisor for the country. I'm delighted to say in 2008 he was awarded an MBE for his services to policing, for the work he was doing around investigative interviewing, and he continued in his role as National Interview Advisor to 2018. Today, Gary joins us as Professor of Investigative Practices from Sunderland University. Gary, thank you for joining us today. I hope everyone online enjoys today's session. Gary will present and we'll do some questions at the end, because I'm sure you'll all have some questions you want to put to Gary after this presentation. So Gary, over to you, and thanks for joining us today.
Yeah, thanks Ben. Thanks for the offer, and thanks to everybody who've taken the time to come on. And you're right, I think it's about a CPD for everybody. And what I would say before I move on, thanks to Claire for reformatting the slides last night. So thanks for that. And what I would say is it's a really difficult time for interviewers at this moment, and the stuff that I'm going to talk about today is just from my experience over the years. It gives you a little bit warm up, so you get a chance to listen to my strong accent, which I've got from the northeast. And everything I'm going to be saying is in line with the College of Policing and with the NPCC interview group, because it's really important that if I'm going to come on and talk on the CPD event, that it links into those. I'm in close contact with both those groups even now. If at the end of the session it just reinforces what you're doing on a daily basis, that's fantastic, because then you're doing what the national picture is, the national position is. If you take a little bit away from it, it's even better, isn't it? So what we're going to do this first session is look at these areas here. Right, so we'll talk through all of these areas. I'll give you a chance to digest that and link it in the interview. At the end, as Ben was saying, we'll do some questions right at the very end. Now, some people might not be able to access the chat bar, I understand. So if you can't, send an email to events@polfed.org. That's events@polfed.org, and Claire will put them cut and paste onto the chat bar, and then we'll talk about that right at the end. So the first session, we're going to cover these. And chance to be a roller coaster of excitement because of the time that we've got. And then the second session, we're going to look at the pre-interview briefing with legal advisors. And I'll mention right at the very end some opportunities, certainly out of the University of Sunderland, around some advanced diplomas for around interviewing, and which is an optional route into the degrees that will run around investigation as well. So we can cover that a little bit at the end. Right, okay, and so I like to keep things simple, and basically, if you strip everything away back, around what makes a good interviewer, and these for me are the 4 key areas. If we can master these or become proficient in these, we'll go quite well to do an effective job when we're interviewing suspects. So, from a planning and prep point of view, we'll talk about a little bit more as I go through the presentation, but there's always time for planning and prep, always, even if there's only 5 minutes. And I think it's really important that we understand when we're going into any interview what we're trying to achieve. And we can only do that by thinking it, so thinking through, because when I go through the construction of the conversation management model of PEACE, the PEACE framework, then it will illustrate how important each different aim of an interview, each different phase has a particular aim as we move on. Stripping back rapport, there's been many things talked about rapport over the years, even now, and by academics within the field, but it's about dealing with people professionally. For me, it's about making sure that you're interacting with people in a way you'd like to be interacting with yourself. Yeah, so it isn't just a particular section of an interview. People sometimes, when you have linear models of interview, say this is the rapport bit, and it's not as simple as that. And we'll link this into the principles about how important it is in your interactions with people from start to finish, whether it's the suspect, whether it's the legal advisor, whether it's your colleagues, the importance of understanding and rapport. Again, question, if everybody on the call today, you've taken your time to come on, so you clearly must be interested in investigative interviewing. And it's important that you think like an investigator. It's important that your questions that you're going to be doing in an interview with a suspect, saying the same for victims and witnesses, but we're concentrating on suspects today. The importance of being clear why you're asking something and what you're trying to achieve. I've done many sessions with people, even now we're going to train and run some case studies and get people to formulate interview plans, and they come back with the questions in the, not always written down, which is fair enough, and we'll talk about that a little bit, but the importance of getting the right questions and ask people, why are you asking those questions? And some people are unsure as to why they're asking them. And it can be like that. You've got to understand what you're doing in an interview to try and prove or disprove somebody's involvement, if you strip it right back. And also from questioning side of it, your job as interviewers is try and gather investigative material from the interview of the suspect if they choose to talk to you, right? So it's important that those questions, if you're going to get somebody to speak about the investigation that you're looking at, it's important to ask the right questions. And likewise, clearly it's important to listen to the answers. And sometimes there's an area which I don't particularly subscribe to, that people are going in interviews with a list of questions. Now, I can understand going into interview with topic and areas and clear aim of what you're trying to achieve, but a list of questions may backfire on you. Understanding the questions that you need to ask within the topic is fine. But if you have a list of questions and you just ask somebody a question and you don't listen to the answer, and I've seen this several occasions, then you might miss something vital. because you're thinking more, well, I've got my question to ask, but listen to what the person is telling you. Because it's really important to be able to do that. So I just wanted to highlight there that if you strip it all back, to the fundamentals of interviewing, for me, there are 4 areas that we need to focus on. Now, the principles and I've had the opportunity of speaking to people around the world in the past when they're looking at developing interview techniques. You've got to your models of interviewing need to be based around the principles. What underpins what you're trying, how you're operating, right? So in the 90s, where and I was brought up on a confession-based culture, and I'm talking the early, from the 70s onwards and until 90 and before that, up until 92, really, when the principles of interviewing first came in for a series of problems with interviewing in the court, which were being criticised, right? That initially, the move was to try and get people away from a confession-based culture. And initially, this principle talked about it's a search for the truth. But as the years go on, and you understand it more, sometimes it's a complex thing about how people view truth in a particular way. So it was amended. These principles were amended in 2009 to take account as well of the current thinking around PIP, which had just been introduced around about 2006 as well. At the same time, at the interviewing, different levels of interviewing were being established, which were the tiers, which are now aligned to PIP, so I'm sure you're aware. This has moved us to say what you're trying to achieve as an investigative interview is obtain an accurate and reliable account, right? Now, the thing from a suspect point of view, you're trying to obtain a reliable account. Often, as we know, people don't supply us with that, but that's what we're trying to achieve, right? So it's really important that we consider everything that we do in our actions, thoughts, and behaviours in our interaction with the suspect. Is there anything we might potentially do to impact on that accurate and reliable account? And we'll talk about this in respect of pre-interview briefing, about information that we supply before we ask the question. So it's a really fundamental principle. If the person, the suspect, chooses to speak, because it's certainly, as we know, it's in their rights, isn't it? It's with their rights first to not to incriminate themselves, not to give us an account. So, but it's important that we try and create that environment in the interview that affords the person the opportunity to give us an account if they choose to do so, right? So that's fundamentally what we're trying to achieve. In the past, vulnerability was exploited. There's no doubt about it. People didn't understand enough about vulnerability. People didn't understand enough about the power of authority and how they were dealing with people in an interview situation, where now we're far better than ever before about understanding vulnerability. Yeah. Now, quite clearly, not only should we be fair, but we should be seen to be fair as well. So it's really important that we consider, and as you know, that the issue of vulnerability, if there's a sniff of a person being vulnerable, thinking about it, then you must treat them as being vulnerable and all the safeguards involved in that. Because ultimately, what you're trying to do as an interviewer is to have the potential of what material you gather from the interview of becoming admissible in the courtroom. Now, we know, don't we, that depending on the state of the interview, within the context of the investigation, not all of it might go before the court, right? But ultimately, that's what we're getting back to, your accurate reliability side of it. That's what we're trying to achieve. So how we deal with vulnerable people and how we question people fairly is quite important, isn't it? So, and you've got to be able to equate that to understand the person who's sitting across the table from you, from the level of and type of questions that you should be asking, because it links a lot into fitness to be interviewed, which I'll cover in some slides further on. Right, so it's really important. Now, we interview vulnerable people every day, but vulnerable people, as we know, commit crime. So we can't stop interviewing vulnerable people, but we've got to make sure of how we deal with vulnerable people, and that's the important bit. Now, this for me, investigative mindset. I interview people all the time. I just kind of stop myself. I interview people when I go for a cup of coffee. The people who are serving us, like bringing us the coffee, and talk to them about their life, and I think it's about being have that interest. So if you've got an interest in what you're looking at, and then in what you're dealing with from an investigator, because you want to do that search for accurate and reliable information, and it clearly develops over time, right? But think like an investigator. I hear people saying, "Well, I'm impartial," and I know what they mean by it, but I don't think people are impartial. You're an investigator. That's your job. You get an allegation, you investigate it, and you're there. You're employed to act as an investigator. So have that mindset, but you've always got to have it within the context of what you're trying to achieve. I've seen interviews where people, clearly something which isn't never going to be relevant, but they spend a long time on something because they don't have a clear approach. They don't have this mindset of this trying to prove or disprove somebody's involvement, right? So it's we need to be asking those difficult questions of people to get to underneath the surface of things, but we can do it in a proper professional manner. Detail is so important, right? I again run sessions where I say to people, there's an account, how do you break it down? And I was having a conversation with an officer this morning from a force, and we're talking about this, about people get surprised if people speak in certain situations. So, I don't think people fully understand the importance of the detail, getting into it, and not having broad brush interviews, like asking people, where were you at dinner time yesterday, or where were you last evening, or last weekend, because you need that detail if you're going to go out and find out exactly, is that what the person is telling you accurate and reliable? So can you act upon it? And that's whether it's a denial, an admission, or an account. Yeah. So it's really important that we go out and test it. We'll only test it out with detail. I often say this thing tongue in cheek to people on courses. You should, if you're going to get a course tattoo, get detail tattooed on your arm, because it's really important. The detail the detail around and clearly points to prove and possible defences come within all part of this. And just a couple more here. You can ask whatever you want in an interview with a suspect, right? As long as there's a purpose behind it, and you're there to trying to obtain material which can assist in investigation, right? So people often say, and sometimes solicitors say in an interview, officer, you can't ask that because it's not evidential. Evidence is what comes out of the courtroom, right? This, clearly, you have to ask questions in a way that's admissible under PACE, right? But you can ask what you want. You don't have to justify to somebody, look, why I'm bringing up in the interview context, I mean, at that time, why you're bringing up evidence, something from co-accused, as co-accused has said next door, or it's anonymous information, or it's a bit of hearsay, right? As long as you've got a purpose to it, you can introduce it because you're trying to obtain material. Now, you might introduce something in an interview which is never going to pass the evidential test for the courtroom, but it might lead it to some material that you from, like, in the name of somebody else who you go to see, etc., right? So, but it's how you obtain it. Yeah. So you've got to be mindful all the time of 76 and 78 of Pearce, which covers like, fairness and oppression. So you can ask what you want. And let's not forget how important admissions are. We've spent years, and in the early days, I think went too far in the early 90s, trying to get people away from confession-based culture, that people wouldn't use the term confessions or admissions for a number of years because they would think it wasn't important anymore. I mean, provable lies are very important, and we'll touch upon that certainly a little bit later. But so as admissions, the benefits of an admission shouldn't be overlooked. Now, it may be, often people get concerned or frustrated, let's a better expression, about no reply interviews. Now, a no reply interview might be what you need at that point after you've done the correct questions, we've talked about before, and you've given the person opportunity to account for everything, and but you've covered all your bases. So when the whole case gets put to a person who was charged and a barrister has a look at it, or the lawyer, they realise the best credit they're going to get is admitting their first opportunity, which is the courtroom, the first appearance at the courtroom, right? So think about it more long. You might get an early admission, but might not be in the interview, because people can't be criticised, right, for not admitting in the interview. The Court of Appeal have looked at that, and they can't, right? They get more, I think, extra credit if they do admit it in the bigger scheme of things, but they can't be penalised for not admitting. They can be penalised for not admitting at the first appearance at court, right? So you've got to think a little bit wider, I think, when you're doing your interview, depending on the context of the investigation that you're involved with. Right, last couple then on the principles. Clearly, and again, I was talking to the officer this morning, asking, I'm doing an input soon, and I want to tell them to a group of people, and I want to find out what the state of play was in a particular force. And I was saying to people, give up in interviewing, because I speak to other forces, and some people, they give up after 2 or 3 minutes, right? And it's that's not to understand interviewing for me, right? And you're not, people also get worried and saying, well, what if I ask the question more than once? Will I be criticised? Well, it's all about context, isn't it? And it's all about, again, the person who's sitting across the table from you. And the courts have said this, the question isn't unfair because it's persistent. But again, persistence isn't about browbeating people, is it? It's about being clear and firm with what you're trying to achieve at any different phase of the interview, right? And really important, and I'll touch on this when we talk about the Court of Appeal views around adverse inferences, which have been very positive for the police, because people sometimes think adverse inferences are a waste of time, but they're certainly not. And I'll highlight some cases a little bit later where it's really important to ask the questions. Not every, in the court is saying this, not every question has to be asked, but key question for me should be asked of people, to give them an opportunity and to think about it, to think about their answers. Because again, being in probably the world of interviewing for as long as I have, there's different things happening on different occasions. There's not it's all everybody no replies. There's not everybody speaks. Everybody's a lie. It's not that. And it's across the years you see all these opportunities where people change the position in interviewing, in the interview room. as well. So there's a big responsibility, I think, to put questions to people. Right then, so that's the basis of the investigative interviewing, whistle stop tour around that side of it. And I think that the principles should be discussed before on every training course myself around things. But getting back to some practicalities around it. It's really important, anybody who we interview as a suspect, whether they're detained or as a voluntary attender, we need to have reasonable suspicion, don't we? Which is based on known facts or information. Now, you have got to articulate that, haven't you, to people? So that, you've got to consider, and we'll talk about what you say to people at point of arrest in a minute. You've got to consider, the investigative material you've got, which gives rise to reasonable suspicion, when you're going to reveal it. Now, quite clearly, you have to articulate that to the custody officer as well, right? So it's important. It's fascinating when I've gone to several jobs over the years and say to people, like, okay, what have you got? In essence, is this, isn't it? What have you got to why you think this person's done it? And some of the answers have been really interesting over the years, right? Because you've got to be able to articulate. It's the fundamental part of why you're speaking to somebody as a suspect. I remember speaking to another country about this, and they said, "Oh, it's great what you've got in England, how you can lock people up off the street to just interview them." And I said, "No, you can't. It's not about just, you've got to base it on some reasonable suspicion. It isn't just, well, look, I fancy this person here, I'll get them in and have a chat with him, is it?" So you've got to be able to articulate this. And it's important because it features as a key part for your pre-interview briefing, the considerations around it, and a key part of your challenges in the suspect interview as well, and how you formulate other parts of your interview. So you need to understand this. Now, I put this slide up here about voluntary interviews, but just to highlight the point, right? That the voluntary interviews are the same level of approach as you would with a detained person, other than the person can leave when they want, if they choose to do so. So you haven't got that power of like keeping them in custody, right? Now, so all the issues that you cover in a suspect, how you think about what you should say, to somebody at point of arrest, you've got to think about this in respect of how we arrange the interview, right? Because is there anything you might do at this point which could impact on the accurate and reliability of the account you're going to get, right? And likewise, you've got to think through, people entitled to legal advice, which you have to tell them, don't you, when you arrange the interview. But the other interesting factor is around vulnerability. If somebody's in custody, the fitness, and there's an issue about fitness to be interviewed, is decision of the custody officer around that. What you have when you interview a voluntary attender is the decision on fitness to be interviewed is down to yourself as the interviewer. And, so I think ultimately you need to understand what fitness to be interviewed means. And I'm going to put a slide up soon, just to explain a little bit of what fitness to be interviewed is about. Because when we did some recent surveys on this, maybe a year or so ago through the university, and I'm not sure everybody's always clear what fitness to be interviewed is, but we'll touch upon, we'll come to it. And likewise, with a voluntary interview, if a person decides to have legal advice, you then have to decide around the pre-interview briefing with the legal advisor, what if your reasonable suspicion and the nature of the case are you going to reveal, right? So it's just to highlight, it's not an easy option. It's not the easier option. And it's, the safeguards around interviewing somebody as a suspect in custody are exactly the same for voluntary interviews. Right, this is just a little snippet of fitness to be interviewed, which is under PS Code C, Annex G. I would suggest everybody, right, on the call today, if you get the chance, have a read of it, just to brush up on it. I was reading it only recently as well, just to keep brushing up on it. And it's only one page in PS. And it talks, because fitness to be interviewed is fundamentally about this, right? Is can the physical and mental state affect the ability to understand what's going on? Can the company and what's being asked and appreciate their answers and making rational decisions? Because often people think, oh, it's about somebody who can't interview people who are drunk or on drugs. Of course you can't, right? But it isn't just about, oh, they're fit now because they've sobered up, or they're fit because they're not on drugs, right? It's wider than that. And sometimes the circumstances of the offence or the crime that you're investigating and arresting them for or interviewing them for as a voluntary attender, it might have an impact on this, right? And we interview vulnerable people, as I said before, all of the time. And sometimes we interview people who've got mental health issues all of the time. But again, this is fundamental to it, because, and I think it has an impact as well on your decisions around pre-interview briefing. Because if you're interviewing people, who are vulnerable and potentially suggestible, you've got to be really careful about the information you give away beforehand. So this isn't about risk assessment. This isn't about whether somebody's going to harm themselves when they leave the station. This isn't about have they got the capacity to plead guilty at court in the future or go to court. It's not about that. It's about this. Yeah. And if you start to read the PS Code C a little bit more, it talks about how the quality of the interview, particularly, and it mentioned the word robust, I'm sure, the robust nature of it, how does it impact? So you might have to think about, well, hang on a minute, this person is fit to be interviewed. However, I've got to really shape me interview and the questions I'm going to ask and how long I'm going to do it around to get the best out of it. Because if you don't, it might throw the whole interview out up there, when it goes to court. Right then. I would normally, if I was in a forum outside, I'll be asking people some questions on this, but I'm just going to see what the answers are, but I'm going to give the answers up front. And there's a big thing, and I've seen over the years, people get confused about what they have to tell somebody at point of arrest and what they choose to tell somebody at point of arrest, right? What you have to is one thing, what you choose to is you're making decisions about. So what we have to tell people at point of arrest is obviously they're under arrest, the caution, the necessity for the arrest, and what the general nature of the offence, right? That's it. We don't have to tell people what investigative material we've got which gives rise to the reasonable suspicion, right? We don't have to tell people at point of arrest. So I hope that's clear, right? And if you say, well, Gary, that's obvious, fantastic, right? But I've seen so many, even at high profile murder cases where people think we've got to tell them we've got to tell that person at point of arrest why we think they've done it. So we have to tell them we've got forensic. We have to tell them, we've got CCTV. We've got to tell them we've got this and that, that. And you don't have to. It's a simple, and this isn't just me saying it, right? This is what the courts are saying and everything else. Obviously, I'm paraphrasing lots of things as well, but right. So if you choose to tell somebody at point of arrest what you've got, that's a matter for you, as long as you've looked at the consequences of that. Now, so and if you've done it for a reason, yeah, if you do because and you've thought that through, that's fine. If you do it because you thought you had to do it, then you're wrong. right? So it's important that you understand what you have. And point of arrest, I've had occasions given advice where, yeah, we've revealed something because of this, of the strategies that are in place afterwards, but you've got to really think it through. But that's rare that I would suggest that, because the person's got to know an intelligence in place, which we'll look on a little bit later when we look at pre-interview briefing. Right, body worn video. The reason I've got this up is basically we saying, look, that body worn video, if you've got a body worn video on a point of arrest, or you know some of your colleagues have been at a point of arrest, make sure you look at the body worn video before you have an interaction with the legal advisor, right? Because again, there might be something on that body worn that's been misheard, like initially at the scene, or being missed, right? And I've put significant statement of silence there, really just to highlight, don't worry about it, right? Don't worry about thinking, well, is it a significant statement? Is it a silence? You know what a silence is, but, you know, could it be a significant statement in the courtroom? Just bring up, right, whatever's said at that point of arrest, bring it up at the beginning of the interview, because there's some things that I've seen, which I think, well, that wouldn't be a significant statement, but they've decided it is a significant statement later. So just bring it up, because Pierce tells you need to bring it up or you can't use it, right? And the other thing is, there's nothing wrong with talking to people in the car, right? Clearly, you can't talk about the offence. You can't talk about interviewing about the offence, right? But there might be occasions where you want to talk to people about first time they've ever been arrested. This is where we're going. Yeah, this is what's going to happen, right? So nothing wrong with talking to people if it's part of your strategy. If part of your strategy is to keep people quiet, well, that's fine. And obviously it depends on the nature of how you're transporting somebody. But if people are talking to you about the offence and you've cautioned them beforehand, that's that's an unsolicited comment. That's up to them, isn't it? As long as you don't start questioning them about it. Clearly, if somebody talking about it in the back of the car and it's recorded, and I would advocate it's best to keep your body worn video on all the way through to the detention site anyway, then bring it up again at the beginning of the interview, right? This thing about briefing of custody staff, just to reinforce the point, right? And again, depend on the nature of the job. If the suspect knows everything, that like being caught for bank rights with the job or whatever the term. So somebody's being locked up for assault in there in the street, right? Then this next bit is not pretty going to matter, but what I'm going to say. But you don't have to brief up the custody officer about what you've got in the presence hearing of the suspect, right? Of course, you've got to brief up the custody staff because, as to what reasonable suspicion you've got, but you don't have to do it in the presence hearing of the suspect. And likewise, if you, as part of your overall pre-interview briefing strategy, you're going to reveal it at the beginning, the custody officer doesn't have to write the chapter and verse in the custody record, right? And so I think a good term often to be putting in, especially again at point of arrest as well, we've got investigative material that's given us rise to reasonable suspicion that you're involved in this offence. Because I'll tell you what investigative material, well, you shouldn't know what it is, but I'll highlight how it's the terms of what investigative material is a little bit later, right? So you've got to, so really, it's all this thing about action and liability. If you're going to say things that might impact on your action and liability of what may be said, i.e. somebody decides to make up a story on the back of what you've told them, right, before you've even asked them a question, you've got to think this through in this timeline of events. So how are you dealing with someone from point of arrest? How are you dealing with him when you get to the custody block? How are you going to, we'll talk about how we deal with a solicitor, and then obviously moving on from there in the interview. All of this is going to be joined up. Right. What I'm going to, the next session is, the next phase I should say, we're going to talk through these areas here. Now, again, fundamentally, people might use different terms depending on which force you're from. But if you go strip it right back to the conversation management model of peace when it was first introduced, and I was one of the trainers, I didn't clearly, I'm not taking the credit for creating peace, but I helped deliver it right from the beginning. The conversation management model is in 3 phases. This I initially was talking about: suspect agenda, police agenda, and challenge. Right? Now people call it different things like police account, suspect account, doesn't matter, right? But that's the 3 different phases which I'm going to talk about, and I've added a couple of little bits and pieces to it that I think makes it a bit more clear, but we'll talk through each bit. The first important bit is relevant time, right? When you're investigating a job, a case, you've got to be clear, what's the relevant time that there's going to be, the parameters that you would want to look at as part of this investigation. So if you have say a robbery in the high street at 12 o'clock midday, it's just a way of explaining it, then clearly you need to look either side of that, not just what's happened at 12 o'clock, but you need to look at what's going on in the morning and perhaps what's going on in the afternoon, especially around the thing from an offender's point of view. And also it's a good model to look at from an investigation point of view, because where you start to gather an investigation, which will lines of inquiry, which will help you in the investigation. So people often talk about the material time frame. And the thing for me, the material time frame is very tight around the actual offence at 12 o'clock, whereby you're going to get into that micro detail about what happened, particularly depending on the nature of the crime for your points to prove side of it, right? But either side of it is really important from an investigator, because it helps to gather, as it says on the investigative material, and also assist in action liability of it. So if you're interviewing a suspect, for example, who says, listen, I was never there, you've got something to implicate them being there, but he says I was never there. By looking at both sides of it, it might help it to prove or disprove that person's involvement. So don't start just right at the material time frame. When you're looking at something, think about the relevant time. And each job dictates what the relevant time is. What's relevant to the interview of a suspect might be a different relevance for interviewing of a victim. Yeah, because depending on the nature of the crime, you might think the activities of the person, the suspect beforehand, is worth exploring, as are the activities afterwards as well. So you need to just think this wider rather than when you start looking at your inquiry, because obviously investigative interviewing links into the context of your investigation. Now, this is in simple terms. Yes, there's other complex scenarios regarding non-recent cases or conspiracies or other types of offences, but I'm talking about the bread and butter type interviews that we're doing on a daily basis, where what we're trying to do is to get an account from the suspect in response to the allegation that you've arrested them for, right? So in this part, what you're trying to do here is ascertain their movements during, or put in brackets, the relevant time, right? So what you're trying to find out is, like by the basis of your first question, what's their response to the allegation? Now, if you're, so I said earlier on about timing and about always time for planning, I think you can plan for this very, very quickly if your aim is to find out, okay, where were they during the relevant time? Yeah, well, obviously when you've outlined the offence, as you have to do, which you'll have done earlier. If a person then denies it, then ask those questions about where they were, those good investigative questions, where they were, who they were with, what they were up to, where did they go, all those great questions, because then you're going to, which allows you to go and explore that, test out if somebody's telling you. Now, likewise, if the no reply, follow the plan, follow your plan. And your plan should be what it just is links back into where were you, who were you with, etc. Give them an opportunity to account, right? Because it's quite important. You don't have to ask every question under the sun, but it's important that when somebody listens to what you've asked, if that person had an account to give, you give them every opportunity to give that account. if they admit it, those occasions where people admit, explore motivation. I've seen people try to explore motivation when somebody no replies, and no reply isn't an admission of guilt, right? So trying to explore motivation isn't, oh, well, he's admitted, he's really admitted, but he's not telling us, I'm just going to explore motivation. You cannot do that. If somebody admits it, explore motivation, because I think that's quite important. And it links into the potential sentence in the sentencing code guidelines, etc., from them around, how the different serious nature of the offence and some possible mitigation. But look at that side of it, because if you don't, it's happened to me where people come to court, those ones who were guilty, and given some mitigation which wasn't true. But I'd found after, but I hadn't covered it in the interview, so it was too late. And as I said there before, probe for detail, right, around it. So you're trying to create this environment for this first interview, which it's like an information gathering exercise, isn't it, for you to deal with. Right. The next phase, the police agenda or police account, or it doesn't matter. You look at this in two bits. You've got to think about what relevant areas might you want to explore as an interviewer, an investigator, which have occurred before the relevant time, and depending on the nature of when the person was arrested, what activities might you want to cover after? Yeah. Now, it's up to you which way you deal with this. That sometimes, if people are arrested at the scene, there isn't any after to consider, quite clearly. If somebody's arrested 2 weeks later or 3 weeks later, there might be some relevant stuff that you want to cover in that after phase. But for me, there's always relevant stuff in the before phase, isn't there? Because it might be the relevant background, maybe lifestyle, but again, it links back to the nature of the crime, right? So, and the more serious the job is, the more these areas become so relevant. And because you might get a lot of motivation in the before section, but also afterwards, you might get a lot of areas which will help you with your case as well, right? Now, it's important. So when I talk about during is that relevant time, which is probably on the day or 2 days, right? The before side is everything before those 2 days. You can go back as far as you want, as long as it's relevant, and everything after up to the point of arrest. Yeah. So just think it through, because it isn't just about an investigative interview. It's very much like witness interview. It isn't just about what happened. Of course, that's really vital, but it's also about other material that you might want to accrue, which might assist you. Yeah. Right, the final phase is your challenge phase, isn't it? Now, your challenge phase is where you're presenting your material, right? You're presenting what you've got, presenting the material that you had initially from which gave rise to reasonable suspicion, up to presenting your material which you've got from the interview. For example, there might be some lies come through the interview which you would show because of what you've got. If somebody said, I'm never there before, but you've got friends that put them at the scene and things like this, right? So it's how you present it. You've got to be structured. It needs to be impactful as well for me. But what it isn't, it's not your opinion. It's not an emotional appeal. Come and think of the families. This, that, and the other. It's not your case theory. Yeah. Because you're an investigator there, you're not judge or jury, right? You're trying to gather that material, which you'll give to the prosecutor to consider if there's going to be a charge. But it's not your, as I say, it's not your opinion. No appeals. I've seen people putting appeals. I think you've done it this way, case theory. This is how it's happened. You don't. All those will just get crossed out, right? Because of a person who did them in the past, years ago, they never went to court, right? And sometimes what you've got to be careful of, if it works, if you're in some of the cases in the past, this is where the pitfalls have come through. if emotional appeals work and the person admits it because of that, and they go to court later and say, well, listen, I only said that and that's all you've got to go with because of what what was happening in the police station, that could be the worst thing that happens to you. I haven't got time to discuss that in more detail, but I've seen that in the past, right? So let's just be professional. You've got your material, let's present it, if you've got it. Just a little bit on special warnings, right? So I'm determined the time's marching on and I'm enjoying myself that much. The special warnings side of it is if it's how to use it in the interview. If the suspect's aware, so for example, you've captured them at the scene, or you've captured them with property on them, or when you do a search of the house and there's property there, right? That you may use that. You use it when you want. People often think, well, I'll just keep it for the challenges. But if they're all aware and you're discussing it right at the very outset, so your first question is, okay, Gary, you've been arrested at the scene. What do you want to tell us about what was going on or what was there, or what's your involvement in what's happening? If the person no replies, give them a warning, because the warning, as long as it links into what I've just said, because the warnings are warning the implications of not speaking. Right? Now, if the suspect isn't aware of it, so you've done a house search and you found some property hidden away, or you've got something back off a computer in a house that they weren't aware of, yeah, or or you've found something like which is in their possession, or and they're not aware of it, not aware that you've got it, keep it back if that's part of your strategy, right? So often people think special ones right for the very end, where they're not, use them where you want. Right. The other thing that comes up often is about bad character. And people say in the interview, well, what gateway are you introducing introducing the gateway into the investigative interview? Or even solicitors say, well, obviously, how are you bringing this up? What gateway are you bringing it for? The gateways have got nothing to do with in the interview room. The gateways are how we apply to get it into the courtroom, right? So you explore somebody's character if you think it's relevant. And often there's lies come out of an interview, people false impressions, or people attacking another person's character may assist in that application in the courtroom, right? But don't worry. I've talked about people's character for years in an interview. If the issue about whether it goes to court or not is another matter, but I've got to be relevant to why I'm bringing it up. And this thing that's happened, and hopefully it's phasing out a bit, of listening to people's convictions at the end of an interview with no purpose, to me is a waste of time, right? And I know from talking to people who've used it, solicitors start arguing, well, you shouldn't be doing this, and I just think I agree with them. I think it's a waste of time without a purpose. If there's a purpose to it, if the MO is so identical or similar to what the offences you've got now, that's different. And also, bad character isn't just about people's previous convictions. It's about how they conduct their life sometimes. It's like reprehensible behaviour, or how they go on. And often in serious cases, I like to have a section where you're dealing with somebody's character and asking them about what type of person they are. Whether it comes to court or not is another matter. But there's got to be a purpose behind it. Right? So if you want to talk about somebody's career in an interview, as long as you're doing it in a proper way and you're not breaching any elements of pace, then do it, as long as there's a purpose. Just to finish off this section, there, summary for your investigator, right? Adopt a professional approach. Think about your style. My style is different from other people's style, isn't it? We're all different, but can all be effective. But style and structure is important. One without the other isn't. And I think sometimes we've got into this robotic way of the interview plans, which is never the intention, right? Of just reading off it and just going through in a robotic way with no style. You've got to interact with people, for me, but you've got to have a structure around it. One without the other isn't as effective. Think about your questions. Think about how you're approaching things. Think about what's going on, and remember, right? As an interviewer, you're under scrutiny. Now, I was brought up in a period where there's no tapes, right? But I'd like to think you operate in a way that would be open to scrutiny. But now you're open to scrutiny so much, and think about this. I think, when I say, and I understand where people are trying to create that environment, because I've said it, haven't I, where you want somebody, a suspect, to speak, but how you go about it's important. And think about it, how would your actions be viewed by others in the court? Let's say you get the victim's family seeing how you were interviewing somebody in the courtroom, when they play it in the court, or it's discussed, and just be professional. That's what I would say from that point of view. Right then, let's move on to this interesting area that we've been talking about for about 30 years. Well, probably a little bit less, to be fair, because when I was brought up in the job in interview, when there was no solicitors to start with, then when solicitors really came in a big way after Police and Criminal Evidence Act, the solicitors were just finding their feet as well. Now, a lot of you are faced with active defence, aren't you, where solicitors are more in your face and things, and it can be a difficult area. But I just want to show where really we should be in our approach with legal advisors. And it's called pre-interview briefing now, as opposed to pre-interview disclosure, simply because disclosure got wrapped up with CBIE and it got really complex because it's two different things. Although, to be fair, disclosure, the overall CBIE disclosure covers it all. Right, so what we're going to do, we'll look at working with legal advisors, we'll look at the PS codes, in the pre-interview briefing side, some tips around that, and then we'll hopefully get to a summary point of view. Right, PS, PS, I think it's really interesting. I think at times, sometimes I get calls from people, and all the answers are in PS actually, where if we have a good look, and it's hard to navigate PS at times as well, where annexes are linked into things. But basically, this fundamentally, and there's more stuff in PS because I was reading it yesterday about the solicitors, is that they're there to protect and advance the rights to their client, 100%. That's what they're there for, right? So, and you shouldn't do anything, right, or seem to be doing anything which undermines somebody's right to silence. Yeah, so they're not obliged to give us an account. Sometimes we get down this line, why are you not giving us an account, and can anything I can do to help you? You don't have to take your solicitor's advice if you don't want to do it. All that stuff which you shouldn't be doing, right? Because at the end of the day, if we do anything which can be seen to undermine their right to silence, or to waive the rights around the caution, then it's going to be problematic, right? So we just got to, for me, accept things. So let's look at some of these areas here, which we're going to look at next, just to clarify what our position is. So that's what we're going to be looking at. Right. A solicitor can intervene, as it says there, right? And also, there's another list of things which I'm going to quickly show you, where the solicitors are encouraged by the training from the Law Society to intervene, right? So if you keep away, hopefully, from some of these areas, then there should be no intervention, should there? Which I'll show you in a minute. And all of the things that the solicitors say they will the guidance said they should intervene in, I agree with, right? So we shouldn't be doing it, but nobody's trained to do the next set of stuff I'll show you in a minute, right? So if we act professionally and understand what we're doing, then we should. I know there's always going to be that issue, isn't there, of a clash on an adversarial system. Of course there is, but we've got to try and manage the process in a professional way. Now, I'm not going to go through all these, right? But from a book for advising a suspect in the police station by Tony Edwards, who is quite an eminent barrister with the Law Society. These are the types of areas, and you all have copies of these slides as well, right? If you don't do any of these, right, then there shouldn't be an intervention, right? And if anybody's viewing your interview later, if there's a rubbing spot about it, then if you keep away from doing any of this, then you should be fine, right? As I say, I would go through every one, but they're self-explanatory, and I haven't got the time to do it anyway. And likewise, some of the, I've seen. I think in the main we're far better of how we approach things now, right? And I think sometimes, it's just a personal opinion, that some of these observations, well, I'd like to think so, are outdated a little bit, right? So we shouldn't be having abusive behaviour, should it? We shouldn't be oppressive, threatening, insulting behaviour. There's some of the things on here, I still think, on the previous slide, we still do, but hopefully not to the extent that it is going to cause a major issue, right? Because sometimes the silence, isn't it? But these are talking about ones which are, you're sitting there for a number of minutes and things. So just consider these, right? Because again, over the years, when I've seen solicitors intervene on tapes that I've been viewing or reviewing, and 95% of the time the solicitors are right because some of these things are happening. But hopefully, it's becoming less and less. Right. We've talked about this before earlier about an arrested person. This is what they must be given, just to reinforce what I've been saying to understand of being arrested. Yeah. And this next bit here, right? They've got to understand the nature of any such offence, and where it's become a little bit complex, I think, over the years, this thing around why it says and why they're suspected of committing it, right? Now, people automatically, or some people automatically think, oh, that means what evidence I've got or what material I've got, so I've got to tell them, right? And it's not meaning that. I remember genuinely, because I was involved with some consultations around the PS codes before and had a good contact. Unfortunately, bless him, the lad's passed away now, but he was in the police powers unit who wrote PS and things. I remember having this conversation about this and saying that why things going to cause some problems, because people will misinterpret it, and people have too much. Now, and also people get confused with this bit, right? Where the people are saying, well, like in solicitors sometimes saying, look, Pierce says you've got to tell us what, why you've got material, what have you got? And it's not that. This bit here, right? This bit here talks about documents and materials which are essential to challenge the lawfulness of the arrest and detention must be made available to the detainee, right? So anything undermines the arrest and material that you've got. Now, what I say to people is, well, surely if you had anything undermined it, you wouldn't be locked up in the first place, right? So this bit in Pierce sometimes gets again misconstrued, but this is about undermining the lawfulness of the arrest, not what's given rise to your reasonable suspicion, what we're talking about as part of a pre-interview briefing. It's challenging the lawfulness of the arrest and detention, right? So there's a distinction. This came out from the European Court, a directive from European Court in the past. And in essence, they were trying to bring other jurisdictions in Europe up to the level of Pierce, right? So, but that obviously had to be acknowledged in Pierce because of where we were at that particular time. But this isn't giving away the material you've got, because I'll explain it even further. right? So even Pierce tells us here, look, that it doesn't require the disclosure of details which might prejudice the criminal investigation. So the prejudice bit is got to be thought by yourself. And whilst, remember, one of the, in pre-interview briefing, in essence, that one of the things were pushed in the past was you have to justify why you're holding material back, right? Now I'm completely the other way around. You've got to justify why you're revealing material, because if you don't think it through, it might prejudice your job, and I've seen that. Yeah. So that bit about decision investigating officer isn't in Pierce. It's me saying that's what it's down to you. So again, the minimum, as we said before, the facts relating to the offence that are not including the time and place. So you've people's got to understand over there what you're arresting for, as in the allegation. But again, I reinforce, you don't have to reveal what you've got. Big slide here, right? This, I helped put this in to Pierce in 2012, right? The amount of people who haven't seen it is unbelievable. In fact, I struggle to find people who've actually seen this, and I think it's so fundamental, especially the last line there, which talks about given the conduct of a formal interview, right? It talks, I should go back a bit, explain why one or more of the arrest criteria apply, and not necessarily disclose any specific details that may undermine or otherwise adversely affect any investigative process. Right? The conduct of a formal interview, when prior disclosure of such details may give the suspect an opportunity to fabricate an innocent explanation or to otherwise conceal lies from the interviewer. So for me, before you've asked the question, if you reveal material which you've never really thought through as to why you're revealing it, it could create that scenario for you, right? So it's a massively, I think, useful paragraph to be used if you're not as confident when you're dealing with solicitors. Because, and the thing for me, that I think the reason people don't see it, I've seen it, is because it's tucked away in Pierce Code G. Because it's quite hard to navigate Pierce, as the Pierce codes I've said before, because there's little one lines, isn't it? Go to this Pierce code, go have a look at the annex and have a look at this, right? But it's fundamental. It's a fundamental aspect. I think it's one of the most powerful things from our point of view, clarity around we don't have to reveal what we've got. Now, people say, oh, well, if you don't, Gary, you'll always get no reply. It doesn't work that way. It's like me saying, reveal it and you'll get a confession. Doesn't work that way either. So you've got to think things through. And for me, I like to hear what somebody's got to say about the allegation before I make decisions about, or ongoing decisions after that about what I'm going to reveal material. Because I said before, admissions are important, of course they are, right? Proof of lies are really important as well, but the worst thing we'll be faced is a fabricated innocent explanation that somebody looks at and think, oh, well, I'm sorry, he's answered that material, he's answered that point, so I kind of take a threshold. It's no good you say, well, he just made it up on the back of what I've said. But at the first outset, because how do you know? How do you know he's made it up or she's made it up? If you've revealed it. A little bit different if you're revealing it later and somebody comes up with another account. That's then it can be said, well, hang on a minute, earlier on, you give us this account, or you said nothing, and now I'm revealing this and you're giving this account. So, I think you've got people that need to think it through. And it is hard to think. It is hard to think things through. It is hard to deal with solicitors and legal advisors in an environment. I know people are busy and there's pressures all the time. But if we don't get this right, then I don't think there's much point to be doing interviews if we're not careful. Right. You heard me talk about investigative material all the time, right? Investigative material is all of this and probably more, but these are the top ones for me. that come out in an investigation. Anything out the back of these topics here could be the material that's giving rise to your suspicion, right? Now, you might have one bit of it, you might have several bits of it. So it all depends. It all comes into your thinking about it, because when a solicitor comes into police station, right, invariably they're going to ask three things, aren't they? What's the job? What have you got? And what's happened today, right? So you need to be thinking about what you're going to tell the solicitor about the nature of the job. Yeah. What you've got, you need to think about, are you going to reveal that or not? And if you do, will it prejudice you? You've got to really think it through. What's happened? Quite clearly, the rest of my point about making sure you've got any significant statements covered properly. But I would also add, look, if there's any vulnerability issues going on, is the person vulnerable? Because I think it's quite important to do that. So that might impact on how the solicitor gives the advice in their private consultation. But also, I like to tell people what the interview is going to be about. That phase, right? Not the whole questions, quite clearly, or the topics, but what the interview is going to be about. So the interview might be about response to the allegation, or the interview might be about, I'm going to talk about their background. And then invariably, when you get to the challenge phase, it might be, okay, these are some of the areas we're going to cover in the interview, right? So I think it helps focus people in. And it looks quite professional, in my experience. These are the types of things, right, from the material point of view, you need to make things about, right? So as I said before, think about the overview of the events, what you're going to say, right? Some of the things you can give without really thinking, like saving a statement, if there's been a medical examination happened, if there's been a vulnerability assessment happened, if you've took samples from the suspect, because they know that's happened. The bits that I've put in brackets around decisions, it's quite clearly that, isn't it? You've got to think through, right? Think through what you're going to reveal in that briefing side. Now, when I've said there, previous interview accounts, brackets, witness or suspect, what I mean is that there might have been interviews of witness in the past, they didn't about giving witness accounts away. It's about giving, if they've been interviews of witness, but they're now a suspect, you might want to cover those, right? Or if they've been interviewed by a suspect previously, but didn't have a solicitor, or now the one-to-one, then you might a summary of what they're being said to give, because I think that helps, again, the professional approach to it. Pre-interview briefing, just some quick summary on it. Adopt a professional approach to it, right? Understand your role, as I've said before, difference between what you have to do and what you choose to do and the consequences of your actions. Understand and accept their role, right? Solicitors, that's their role and what they want to do. But you've got your role, right? Will there be a clash in the adversarial system? Of course there will. There's bound to be, isn't there? By the term adversarial system. But you'll be professional about it and think it through. Fundamentally, right, it's all your decision about what's revealed. But manage the process properly and keep records. Keep your written records of it. Now, I'm not going to go through these, right? But you can research these yourselves if you wanted to. But basically, these are a lot of court cases from the Courts of Appeal, which have some really interesting points about the adverse inference and the direction to the jury, right? And whether being accepted. On this next slide, these are my observations quickly about having a look through at those cases. Where an adverse inference will be drawn is when it's a fact which it could have reasonably been expected to mention, right? So what they talk about in that last bullet point there, the Court of Appeal talked about the onus is on the suspect because they've lived their experience, right? So if they've lived it, there's no onus on them to tell you, right? Now, and it's interesting because although it's been everyone's right to silence is clearly there, An adverse inference, though, kicks in, doesn't it, when somebody gives an account that they haven't given previously, which might have been of no reply, or they've changed their account. So if and this is what those cases that I put on the previous slide talk about. Now, what some of the Courts of Appeal have said as well, the cases, there's no requirement, right, for the police to ask every particular question. But for me, you've got to give them an opportunity to, like, even simply tell us what you want to tell us about this particular time or this particular topic, and also give them an opportunity for to digest and think about it. And that's why I put in the length of interview as a factor. So if our interviews are only 2 minutes, or 2 minutes, a bit harsh, isn't it? But they're only like 20 minutes or something for a serious job, and we're putting some serious things to people, we need to give people that time to consider their position. Yeah. So it's definitely worth having a read through some of those Courts of Appeal cases, because people are saying adverse inferences aren't important. Well, I think they are important, very much the same as special warnings and side of it, because they're all tools that you need to consider using in an effective way, right? So you don't have to ask every mortal question under the sun, but you've got to have those questions. I was talking to somebody, in fact, yesterday at the university, who I was at a graduation ceremony, and I was just talking to somebody who had been on jury service, and I asked her, like, did you have anything around interviewing? And it was a serious offence, and she said, oh, we saw the interviews, which they were playing on video, which I thought was great, playing them in the court. Didn't go into the case quite clearly. But I said, what come up about the interview? She says, well, we're wondering, there was missed opportunities in the interview, because, and it wasn't just edited, the people were asked, the plaintiff's entirety, and the questions, we think, why didn't the officer ask that question about it? You know what I mean? So I think, again, it's asking those questions, even if you're not getting the answers, an insightful question, to stop if somebody comes up later and says, well, I wasn't really given the opportunity to ask to answer those, because I felt under so much pressure. It was all came on top. We only had 20 minutes or whatever. So think it through again towards like adverse inferences. I mean, what I'm doing today is just a snippet on that. I mean, we could do hours on each of the topics. Like, now I think also wanting to assist you is creating, which I put together years ago, it's adverse inference package, right? So if you want to try and maximize your adverse inferences, keep a little package of what your interview plan was, which is important, what pre-interview briefing you did, how long the interview was, of your suspect interviews, so it shows like where you actually interviewing for an hour or whatever, how long the consultations were in between, because again, that's with a legal advisor, and the suspect, because that shows you, doesn't it, that they have that time to consider or not. Did you bring in a special warning? Was it appropriate? Was the prepared statement brought up? And the last one, I don't think we do enough around defence statements. If a defence statement comes in, I know some of them are still coming on the day of the court, but the ones who were getting in earlier, are we marrying them and matching up against the interview to say, well, hang on a minute, we covered all that and we asked that. But, so it's all about getting on the front foot around these things. Now, we're not going to do an adverse inference package on every job, but some of the most, like, the jobs where the more serious ones where you're probably going to apply for an adverse inference or the potential of it. So you might want to do it on that. Right. They're just some highlights of what we're talking about, case by case basis. Pre-interview briefing is really important. In a lot of the jobs that I've gone in around the country over the last several years, the pre-interview briefing side, we've had many debates about it, because you've got to know where you stand and you've got to know what you're trying to achieve. Yeah, and how it all plays out in future proceedings, as it says on there. Now, so that just quickly, a little bit explanation of what I'm up to at the uni. I'll lead on this centre for all of these types of areas here, and we have a campus in London as well as in Sunderland. We've had people, some of you from the call may have already been on the diplomas, or you may have been on the degrees that we've had in place. Again, I'm not going to go into this massively, so I haven't got the time. But again, this is on the slide. For people who are specialist interviewers already in those 3 categories there, and I focus on this because of today, of the nature of the today, is we've got an advanced diploma commencing back in the January 6 month at the cost of £425, right? And I'll show you what it is on the next slide very quickly, what it entails. If you do that, so those people who are already specialist interviewers, it provides you a route to come on the BA next year. If you're PIP 2 and you want to come on the BA anyway, but you're not a specialist interviewer, you can still come on it, and that would cost just over £4,500, just under. But if you come through the route of a specialist interviewer, then you can get it for just under £3,000, because that means and you've done the diploma. So in essence, about £1,000 cheaper. Now that's in essence what. Oops, I'll quickly put that back. That's what the diploma is about. This particular one, it isn't about abstractions from the workplace. It's about a couple of essays around some academic work, which would tell you about if you came on the program, chosen by yourselves. At the end of it, we'll have a discussion. I've got some diplomas running at the minute, which I'm discussing with people next week around the learning from the essays, and you have to do a short CPD plan of where you intend to concentrate on as you complete the diplomas, and it carries this academic credits. So that's just a quickly, again for the time. There's some links that you might want to look at, and that's me at the end. Anybody who's interested in a bit further or higher education, either email me there or give us a ring, and I'll talk you through a little bit more. But I'm open to questions. I know I've only got like 5 minutes, I think, there, Ben.
Gary, thank you. That was fascinating, as I knew it would be. And those watching, I hope you've enjoyed it. Gary, we spoke the other day, and the one thing I missed as I've moved through the ranks is interviewing. It is always the best challenge, and it has been fantastic hearing from you today. There aren't any questions in the chat box. I know lots of colleagues can't access it from police systems. So if anyone does have a question they want to ask Gary, we've got 5 minutes, but we can overrun. It's not a problem. This is an opportunity to pick Gary's brains. It's event@polfed.org. While someone does that, Rachel Fairbairn, please unmute yourself.
Sorry, I was just going to email it through, but I will shout up then if you can hear me all right. My question is, does a special warning actually give you any real further advantage beyond the caution? I'm not sure if I'm missing something, but at some point we've been warned over the years about reminding suspects of the terms of the caution in mid-interview in case it suggests that the client didn't understand the caution in the beginning. However, I would sort of say if you handle that reminder carefully, doesn't the special warning cover much the same issues, really, just focusing down on their failure to account for a particular issue? Am I missing something, or what does it give you?
Right. Well, the difference, Rachel, it first of all is if the adverse inference only comes into play if the person brings up a different account at the court, right? So if the person no replies in the interview, but then still no replies at the court in respect of not coming up with a defence in respect of it, then adverse inferences don't kick in, right? However, special warning is different. A special warning, if you interview somebody and the special warning and the person doesn't give you an account, the special warning still applies at the court, right? So if they don't come up with another account, the special warning application can still apply. So that's the difference.
Is it just effectively a focused challenge?
Well, Well, I think when if you look at the history of why it was brought in, right, it was brought in because when Pierce came in, right, and obviously a lot of people got a solicitor, people no reply, didn't they? And then what they used to come up with was called the ambush defence at court, where they brought up a story which they should have said right at the very outset. So the courts were saying, well, hang on a minute, if you've got an account to give, you should give it at the beginning. But the special warning is so new, I suppose, in a set of circumstances whereby it begs the question for anybody, why would an innocent person give an account at that time? Yeah. So if somebody's captured at the scene, but then they come up with if they come up with another account later, the special warning still applies. Yeah. I agree with you when you say it is a focus challenge, because it is. Right. The same as the implications for giving the caution. I think also you've got to be careful, and I think you're right to highlight that, about how many times you give the caution through the interview. So you're not seen to be trying to undermine somebody's right to silence, right? So I would say there's two distinct, but you're right, the linked in processes, if that makes sense. So I would continue to use them. I think the important bit is making sure you use them correctly and that the material, the circumstances fit. Because some people think forensic at the scene of a crime is a special warning, and it isn't. Right? So when people think, oh, I've got your fingerprints at the scene, that's a special warning, and it isn't. Because you've got to look at, it's got to be in people's possession. Now, because many a reason why there's a fingerprint at the scene. So the special warning is brought in to say, look, it's so specific, that's so obvious that a person should give an account at that time. Where the adverse inference bit, there's more, there's reasons sometimes why people might hide behind not giving an account.
And ultimately, all that happens when you give that special warning is that in the court, the judge will effectively, or it will be played out in the interview, or the judge will remind the jury of that point that was raised when they're in their consideration. That's all that happens. There's no other mechanisms. Yeah. And
but it is, as at times it happens more and more in the courts that I think that people realise. Yeah.
Lovely. Thank you very much.
All right.
Fantastic. Next up, we have Kerry Williams. Kerry Williams.
Hi, thank you. My question is around vulnerability of suspects for a voluntary interview. And how far would you go in making those reasonable inquiries around a suspect's vulnerability for a voluntary?
I think first of all, and all offences are important, aren't they? And all in nature of serious. However, it depends on the nature of the job you're looking at, first of all, doesn't it? Because you need to take more cognizance for me if it's more serious, if that makes sense. I'm not trying to devalue, but practically, from lines of inquiry, it depends what you're looking at. Yeah, if somebody's going to get like a caution, might be different for somebody, depending on where you go with a case. But I think the important bit is depending on what the vulnerability aspect is. What do you think the vulnerability, is, and are you satisfied ultimately that you've done enough to ensure that person is fit for interview? I think the voluntary interview side around vulnerability is a big problem myself, because it's quite a complex area as to how can you work out whether that person's got enough rationale to understand the nature of the questions. And you know what I mean? So I think for me, the protection of custody and the protection around a medical practitioner assessing somebody is far safer. So, but it's easier said than done. So again, that was my point about what type of offence you're looking at.
Yeah.
Yeah, and that's not devaluing any offences, but I think practically you've got to think that side of it through. So, and again, it equates back to the types of questions you're going to be doing, how you're going to deal with that person. But ultimately, if you're satisfied that you've done enough to protect that person's vulnerability, then that's all you can do, isn't it?
Yeah, thank you very much.
Thanks, Gary. Great answer. The last person we've got is Amanda Southley. Amanda.
Hello, Gary. Yeah, my question is can you recommend any further reading for the guidance on what evidence to give or not give during briefing or pre-interview briefing? Like why are we withholding some things and disclosing others? It's something I don't think I'm trained enough on.
Right. There's certainly if you go on the College of Policing website, like, there's certainly we put together. And you can email me if you like with it. I've when I was on the national group, we'll put together 3 or 4 documents around this thing. So there's national positional statements, as they were called then, around dealing with solicitors, right? Which some of them are on the College of Policing website. But if you email us, then I'll send you them.
Perfect. Thank you very much.
Yeah, and that helps. But at the end of the day, it's all about you. You've got to make those decisions in the context of the job. So I'm not going to tell you every time you do this and every time you do that, because that won't work. You've got to look at the circumstances and what you're facing.
Okay, perfect. Thank you.
But I think that's good rule of thumb for me is let's not second guess everything, and let's just go with what's faced in front of us, not thinking, well, if I do, it could be this, they could say this, or it could be this. Let's just see what people have got to say without revealing our hand.
Okay. Thank you.
Gary, thank you so much. I can't believe 90 minutes have gone so quickly. Thank you, everyone, for joining. There is in the chat bar, for those who can access it, a bit of feedback. Please do feed it back. We're really trying to make these CPD events worthwhile for you all nationally. So you'll scan the QR code. It'll probably be quicker for those who can't use the link, or click on the link. Please give us your feedback. We want to know what you think. But thank you, Gary, once again. Fascinating talk. Those who do, I would recommend those people having to think about the qualification. It's an ability to take what you do every day and professionalize it. I know several colleagues who have done this, really enjoyed it. In fact, they've been taught by Gary. So do consider it, and obviously speak to your forces around spreading the word. So this webinar is recorded, and it will be available for you to watch again, share with colleagues, and I hope you join us again in the new year for our next detective webinar, which we will notify the title of shortly. But lastly, it just leaves me to say, Gary, once again, thank you. Pleasure to have you this afternoon, and I bid you all a good afternoon.
Thanks, Ben.